So, welcome everyone. This is uh, our series of special webinars that we have starting today to the end of March. And the first one that we're holding today is on conflict resolution, dispute resolutions. And I have the privilege of asking Richard Moore to give our talk today. Richard, he practiced law in Ottawa almost 30 years. He's been retired from practicing law, and he exclusively in conflict resolution, delivery services of mediation, investigation. He coaches conflict resolution. He gives a series of courses on conflict resolution. He was probably one of the leads, I think, in Canada on dispute resolutions. He's been in since 1990, and he's worked in a number of areas, police courts, lots of work on indigenous issues, real estate, personal injuries, working with hospitals, organizations. He's also worked overseas and on dispute resolutions and mediation practices. He also does a lot of mentoring on just alternative dispute resolutions, and he's been actively involved in the national organizations on the ADR Institute of Canada. So he's been incredibly involved. I've been lucky to know Richard for the past 20 years, and he actually wrote our piece on the manual we did on the housing policy. He wrote a piece in there on alternative dispute resolution. So at no further delay, I will turn it to Richard.
Thanks, John, and welcome everyone. I can see some names in front of me, not faces, but names. So thank you all for joining us this afternoon. I would much rather hear you talk than hear me talk. So I'm going to try and keep my remarks fairly short, maybe 15 or 20 minutes, and then hope we can have a good, lively discussion, questions, any topics you'd like covered. We can certainly try and see if we can help out with those. Also, if as I'm speaking, you feel that you'd like to ask a question, then feel free to do so. We can do that, I think, either through our chat function or perhaps by turning on your video. So I just wanted to talk a little bit about dispute resolution and then alternative dispute resolution, what that means, and some of the implications that it has for you and your work. Perhaps we should start off by quickly talking about what is a dispute, and pretty simple. If someone, if you believe that someone has harmed you, and you decide to make a claim against them, and they reject that claim, then you have a dispute. Give you an example. Last fall, my neighbor gave me $1,000, and I gave him my ATV on the understanding that in the spring, by May 1st, he'd give me an additional $2,000. May 1st has come and gone. I haven't seen my $2,000, so I go to my neighbor, I knock on his door, I ask for my machine back, and he says, no, it's now his, and he refuses to give it back to me. So there is a dispute. And what do we do? What do I do about it? Well, I could decide to do nothing, or I can decide to move to move forward with it. And how disputes are resolved is basically three main approaches to resolving disputes. One is a power-based approach, and really, as the name implies, it's determined by who's the most powerful. Examples of power-based disputes, power approaches would include things like walkouts or strikes or voting, blockades, often self-help measures. So in the case where I gave my neighbor my boat and he didn't return it, I could go and take it back or try and take it back. That would be an example of a power-based approach to trying to resolve that dispute. Part of the challenges with power-based approaches is that they can have a high cost often, and often low predictability in terms of what the final outcomes will be. A second and very common way to approach resolving dispute is by using a rights-based approach. And that's, you do that by having someone decide who is right and who is wrong in the particular case. Rights-based approaches are typically informed by the law or by precedent or by custom, by contract. And those rights-based approaches are generally adversarial, and they're played out in the courts. The people who go to the courts ask the judge to make a decision, so they give up their decision-making ability and give it over to a third party who makes a decision. The third and final approach to resolving disputes is what we call an interest-based approach. And using those approaches, we decide a dispute on the basis of what's most important to the people. What it is that really drives them, what are their concerns, their hopes for the future, those kinds of things. And interest-based processes often include things like negotiation or conciliation, mediation, traditional circles could be an example of an interest-based approach. And so when you have a dispute, you need to think about what's the best approach for you, what makes sense. And of course, that depends on the nature of the dispute, what it's about, and who it's with. There's a million topics we could talk about where we can get into disputes. We can get into disputes with governments, other governments, or our own governments. We can get in dispute with our family, with neighbors, with business partners, with suppliers, council. We can get in disputes over contracts, over personal injuries, over property damage. There's no end to the kinds of disputes that we can find ourselves embroiled in. We can be involved in a dispute with one person. We can have a two-party dispute, or we can have a family dispute. We can have large party disputes. And so, of course, depending on who it is and how important the dispute is to you, those kinds of factors will determine what process we use to try and resolve it. Some of the things that we think about when we decide how we're going to resolve disputes is how long it's going to take, how much it's going to cost, how much of an emotional energy will it take, what's the effect going to be on the people that we're having a dispute with, on our relationships with them? How familiar are we with the processes that we use or can choose from? Are the processes uh, culturally appropriate for us? Those are some of the things that we need to think about. In my dispute with my neighbor over the boat that we talked about earlier, if if we're now in the spring and I want to get the boat back so I can go fishing over the summer, I may not want to go to court because you may have to wait 3 years. The fish will all be gone by the time I get my boat back. So we think things like time and cost, how much is it going to cost, and the relationship with my neighbor. Can I talk to him about it? Will that make a difference in my relationship as opposed to whether I, go and sue him? Or if, I go in the middle of the night with 3 of my buddies and take the boat back, how will that affect my relationships? And that's a big piece is what effect the processes we choose on the relationships. So what is alternative dispute resolution? Alternative dispute resolution basically means what are the ways that we can resolve our disputes without having to go to court? What are our choices other than going to court? We have a basic spectrum. I think, John, maybe you could put that up for us now. We could take a look at that, which sets out.
All right.
Thanks, John. The main choices that we have. Well, first, I guess it's probably too late for me with my neighbor right now because I'm already embroiled in a dispute. But if possible, we want to try and prevent disputes in the first place. And we can prevent disputes often by just, talking things through with people, engaging with them, trying to sort out any misunderstandings before they happen or very early on. Those are ways that can prevent us from being in a situation where we have to go into some kind of a formal process. Another way to avoid disputes, particularly having to go to court, is to put, let's say you're working in business, and put a clause in your business contracts to say that if there is a dispute that arises, you're not going to go to court. You agree that you're going to go to ADR, alternative dispute resolution, which will be something other than the courts. And why would we choose processes other than the courts? Well, some reasons come quickly to mind, of course. Can be quicker, for sure. You know how long it takes for us often to get into court. It can often be cheaper. When we go to court, everything becomes public. If we can go to an alternative process, we can have privacy so that we don't have to worry about other people, seeing what's going on and looking at our affairs. And of course, other processes can be more culturally appropriate. The courts, of course, are very adversarial, and I think for many communities, that's not the preferred way. It just doesn't resonate with the way that many people think and live their lives. So how can we how can we then avoid going to court but still resolve our disputes? Well, we can negotiate, and we in this business we try and recommend to people that you choose the lowest cost and earliest available process to help you resolve your disputes, so they're not hanging around. The cost of having unresolved disputes can be terribly high for the individual, for our families, for our communities. And so the first way is to negotiate it, and that's really to sit down with the people on the other side and talk directly with them to see if we can figure out something that works for us and works for them, and we can come up with some kind of an agreement that we can live with. There's lots of people training other people how to become better negotiators. It's a skill that we can learn. It's not rocket science. A little bit of training, 2 or 3 days of training can go a long way to helping us feel more comfortable in negotiating and helping us become much more effective in negotiating. And when we're negotiating, of course, we keep control over the final decision, and a decision that both us and our negotiating adversaries will have to agree to. So the decision making is still ours. Sometimes we need help. Even with the best of intentions and the best of trying, we can't come up with an agreement with our adversaries, and we can bring in a third party, another person, to help us with those negotiations. And that's what we call mediation. A mediator typically be, at least in the Western approach, a neutral person who would have no connection with the parties to the dispute, would not know them personally, would not be in any kind of a conflict of interest, which is always important. That mediator helps the parties communicate better, talk together to see if he or she, if they can help the parties come to a solution that makes sense to them. And the mediator doesn't impose any solution on the parties. It's up to them to decide what is best for them. That's a more and more common approach now, particularly, I would say, since the 1980s. We've seen a lot more mediated approaches to resolution. If that doesn't work, if mediation doesn't work, then the last step we can do is we can give up our decision-making power, and we can go and have a third party make the decision for us. These would be typically more adversarial, where I would say what I thought, what my position was. If we're talking about the boat that I was selling to my neighbor, I would tell it wouldn't be a judge, it would be an arbitrator. I would tell the arbitrator what my case is, and then the other side would say what their case is, and the arbitrator would make their decision. Again, that's more adversarial, but would not be as adversarial as if you were in a court, because the courts have very preset rules, very rigid rules, which I don't really change for anybody. If we are going in an alternative, an ADR approach, and we choose arbitration instead of going to the courts, we can sit down and we can make the processes more informal if we want. There's more room for us to make a process that makes more sense to us. And as we move all along this spectrum, you'll see we have listed here some of the attributes of each. We go from the informal, which is really sitting down and talking about it to see if we can come up with something together, move over to the formal, which is giving up our decision-making power and allowing, having the judge decide. As we move from the informal to the formal, we go from a more, what's important to us, a more interest-based approach, over to what are the legal rights. We go from a more collaborative approach to an adversarial approach. We go from a less expensive to a much more expensive process, from private to public. And of course, if we keep the decision-making power in our own hands, then we have more of a potential to come up with something that we can live with, or maybe we can get at least what's most important to us. Whereas if we give all the decision-making to somebody else, then we could end up in a real win-lose situation, and you could be really disappointed. And of course, I've never heard anybody come away from a court case saying, my God, that was the best thing that ever happened to my relationship. Of course, by the time you're finished with a court case, the relationship you've had with any of the people that you've been involved with is pretty well toast. I think that maybe most of what I wanted to talk about. I guess just in finishing up, I might say that from there may be some special considerations from an indigenous point of view, that if you're able to design a process to resolve your dispute, it can be one which would resonate more with you, one that makes more sense to you from where you are and in your communities. And I guess the last thing I would say is, in addition to looking at ADR, alternative dispute resolution, from just the lens of single dispute, we can also look at it from the point of view of making a whole system, an alternative dispute resolution system, which can be constructed in our own communities in ways that make sense to us. And then we will be able to avoid having to go to the mainstream courts, and you can look after many of your disputes within your own communities, with the input of people that you know and that you trust, and taking into account the things that are important to you and your communities. And I think that's a really a great opportunity that is available now for those who want to think about it and take the time to develop those kinds of systems. So I guess one last thing before I stop, and we can maybe take some questions or have some discussions, is who are these people that will help you with these disputes? Who are these mediators and these arbitrators? Where do you find them? How much do they cost? All of that. Well, first of all, they don't have to be lawyers, so that can be good news for many of us. They don't have to be lawyers. These are people who are specially trained in mediation or negotiation, or both. They may have subject matter expertise. The costs can be anywhere from, I don't know, maybe $100 or $125 an hour, up to being, as costly as the costly lawyers, $500 or $600 an hour. But that's very rare, that you would find mediators or arbitrators costing as much as lawyers. And the good thing, of course, often is that you can share the cost. So if you're mediating, then usually both people pay, or both parties pay, and you can share the costs that way as well. So I think with that, I'll just stop, and we'll see if anyone has any questions or areas we'd like to discuss.
It's John Kudrowski. So I guess the question is, how are disputes currently resolved in the communities? I'd be interested in getting feedback by some in terms of how disputes are currently settled, or do you settle them, or do you let bygones be bygones, or I'd be very interested on how disputes, because we know there are many disputes possibly in communities ranging from tenant landlord, if you collect rent, disputes on people who may not be on a housing list and disputing that they should be a priority, disputes relating to hiring contractors, disputes with chief and councils, especially when they change a project midstream, dispute with neighbors, dispute with lands. So there's a number of disputes, and I'm just wondering, and I open it for discussion, how some of these disputes are settled. So I'll open up the floor to people to give some feedback. You have to unmute yourself first, I believe.
Must be nice to live in communities where there's no disputes.
Oh, go ahead. Elvis, how do you guys settle your disputes on contractors? Not sure if I'm being heard. You can hear me, right?
I can hear you fine, John.
Claude?
Here's one. Our disputes all seem to end up on the desks of chief and council.
All right.
Mm-hmm.
Yeah, chief and council. So how does chief and council dispute? I guess they try to weigh the balance, they politicize it at the same time. And again, it's based on my understanding, chiefs and councils, they're not really independent, right, Richard? Would you say that may not be the best avenue because they would have some interest?
Well, they could, John. It certainly depends on the disputes, and if I would think that quite often the chiefs and council would, being part of the communities, may know some of the parties in the dispute, may know some more than others, that might lead to conflicts or unhappiness with decisions. I'd also be interested to know, how people are able to make their cases to the chief or the council.
So we have a comment from Melanie. So some very good dispute samples. I don't have a microphone, but I am new to the role, so fortunately I haven't to deal with any yet. But I am curious from all the samples you provided, how they would be resolved. Case study for each of those at another webinar would be helpful for when the time comes, there would be examples for us to guide us. I believe right now, if a dispute came to my attention, I would request for each of the tenants that they would like to see to resolve and then work from there on how to please both parties. It could be different. I could offer different solutions that may both parties happen. I would bring that forward to chief and councils. So I guess, somebody in Melanie's position, she would try to resolve it and bring the solution to chiefs and councils. So then it becomes a question of how does one balance the views, right? And so how does one gather the information? Like, can you go into more detail? Like, how do you settle the dispute? Like, do you ask for a certain information? Do you try to weigh the balances? Can you give a little more example? So let's just take what Melanie, like, what's the methodology? What's the approach?
Well, here, what Melanie's talking about is she's talking about playing the role of a mediator between the two tenants. What I find is if you just take some time, you get both parties together and you take some time and you're interested in what the situation is, and you give each person a chance to really talk about how they see things from their perspective, and also set up the conversation so they will listen to the other party. Usually, the solutions really seem to tend to come on their own. It's almost magical in some ways that happens, because once somebody hears how the other person is being affected by what they're doing, that can really change people's attitudes, and I think people really don't like living in conflict. They want to be good people and good neighbors, and usually I find we can work these things out. It takes some special training sometimes. Some people are naturally good listeners and naturally good mediators. Some people, can benefit from a little bit of training. The most important pieces, I think, are being able to feel more comfortable if there's some high emotion, and how to work through that with people. That's not avoid the conflict, but to try and work through it, I think, is one of the biggest learnings that people need to have when they try and go into this work.
So if I live in a community, which many are very homogeneous, right? They're close. People within the communities live among each other for years, and is it always best to try to use somebody within the community, or is it best to somebody outside? Because it's been my experience, and I just thinking of a number of communities where, like, the dispute is like generations. And how does one overcome, knowing the history and trying to get past the history? So I know in a couple of examples I've been in, they sort of asked me to sort of, look at what's being presented because I had no idea of the history. I was just taking information on pretty much on face value and then trying to find the win-win situation, whatever that means. Because you try to you find that balance that people can move forward on. So, but it makes it tough if you're living in the community. So, is there really a need to bring people from possibly from the outside who won't have community biases? I guess is the best way to try to phrase that. It's
Mhm. I would think probably with something that may be really long-standing, even generational, you may want to bring somebody in from outside the community. It can still be somebody, that understands, the culture and understands what's important to people, but maybe removed from the community would be a good idea. I think there's an opportunity for communities perhaps to band together and maybe develop some capacity, maybe train some mediators or arbitrators. And so if there's a dispute that comes up in one community and people think, because it's really what people want, John, it's what people feel comfortable with. If people feel comfortable of going to someone in the community, maybe an elder or someone that they trust, then there's nothing wrong with that. If they feel reluctant to do that, then you want to go bring somebody else in. And I think there's an opportunity to develop some training, within different First Nations, for example. And if you have to bring someone in from a neighboring community or to help resolve that dispute, then at least you have someone who perhaps understands the communities a little bit better than someone from downtown Toronto.
Go ahead. Does anybody else have any questions?
I remember years ago, and I was in Guyana, and I was doing some training, and there were a number of mostly government people and people from the city, but there were a number of traditional chiefs came to the training, maybe 5 or 6. They had 3 days, and it was mediation training, and these people lived, quite deep in the jungle, and they were in their own small communities, and so their life circumstance was quite different than mine. So after the training was over, I was speaking with them, and I asked them. I said, "Does this make any sense? What we've been talking about and I've been teaching over the last 3 days?" And if you remember, if it's mediation training, that's where you're training people to help them come up with their own solutions, right? And that's what I was training. And the chief said, "Well, yeah, it makes some sense, but I don't think we're going to tell our people that it's mediation that we were studying, because when they come to see us with their problems, they expect us to make the decisions. But so we're still going to have to make the decisions, But what we learned was we really learned how to be better listeners and how to wait until people have had a chance to really talk about everything that was important to them before we made the decisions. And because we've learned that, now we feel that we can make better decisions. So, I found that really, really interesting, right? And I think what we need to do is we need to, take what comes natural to us in our, from our own experiences in our own communities and use that, but also maybe shape things in ways that we can improve. Um, we can improve.
So how does, go ahead. Okay. All right. So how does, so in many communities, there are leaders. So you made reference to the elders, and the women in many communities are also fairly, prominent in terms of decision making and leaders. How do they become more involved? Like, how does one try to get involved in disputes you know, without minding your own business, but making it to mind it to be your business to try to resolve it in a community? So is one invited in, or is somebody just, offers, or how in the communities does somebody try to settle disputes? So Melanie and many on here, they try to settle dispute because of their proximity. They're managing the file, but how do you pull in like a third party, or do you need a third party? Again, I'm just trying to think of community that's has to work with its internal capacities.
I'll give you an example of working with the community 2 or 3 years ago, and they were working on a project in collaboration with the courts just outside their community. And they were developing traditional circles to deal with issues, mostly with younger people in trouble with the law. And what they did, John, was they developed a program, and then they asked for volunteers from the community who would be interested, and they got different backgrounds. So they may have got, somebody with a social work background, maybe there was a teacher, there was both social workers and teachers. And so they brought together 10 or 12 people who would volunteer to help resolve these disputes. And they were trained, and they became a resource within the community. And so if a certain situation came up, then the coordinator would call in people to help, form a circle with the parties who were involved in the dispute. And that worked really quite well in that particular community. So that's one way you can do it. By just a real, a particular program. I think that would be fairly easy to organize if you, for instance, if you had a housing program. I think you could organize something like that. I'm not saying you'd want to use circles for that, but somebody in those positions, like Melanie's position, for example, could get some training, or there could be 2 or 3 other people to get some training.
Right.
I've also worked on developing community program, mediation program, housed by volunteers, and that can work well.
Okay, I noticed on Mike, you can go ahead with a question there.
I don't exactly have a question. It's more, it's not even new information. It's just based off of experience that I've had in the past. So traditionally, the way our people, the Haudenosaunee Iroquois, would have resolved a sort of dispute would be exactly as you guys have mentioned, to sit down and hear out both sides of the dispute. It would have happened in the form of like a council. Some of this is still practiced, but it's not implemented on the government level because pretty much the government level has been taken over by band council. So it's more like it happens more on a social level where we actually will sit down in council and for as long as it takes, discuss back and forth the issue until we can come to a consensus. And when things can't come to a consensus, it pretty much gets put to the side until it can be revisited. But I think a lot of the answers could come from, like, we all come from communities that are places for people who had traditional cultures, and we had a lot of these things worked out in the past. So my advice would be to look back to the old ways and maybe not use just the old ways, but I mean, the reality is we all live under band councils now. So of course you're going to have to find a balance between old and new, because there's certain programs and funding that needs to be accessed. And I think the more you could incorporate whatever sort of dispute resolution our people may have honed over centuries could very much help, because our communities need a lot of healing, and a lot of that is going to come from the past. And I don't know, that's the best I could offer in trying to organically come up with some sort of dispute resolution that works for your community. That's all.
I think that's really good advice. I think there's so much wisdom. Some of it has maybe not been used so much lately, or that you know the traditional approach has not have been used so much recently. But there's so much wisdom, and to be able to find and use those traditional processes and adapt them where you have to is really, really key. Really key.
Yeah, because that's what it sounds like it's coming down to with just your advice from the beginning of the webinar, is for those who don't have any sort of protocol in place, it basically comes down to just having to hear out the individuals, bring them together, speak your experience, and back and forth until we can come to some sort of understanding. And that may not always be the case, but at least you're hearing each other out and respectfully hearing each other out.
And I think using those processes are the ones that really make sense to people. I think where as a community you can come together maybe and help create spaces or venues where people know if they have a problem, they can go there, and there's someone there that they can get, you know, have their talks organized, or people know where to go and who to go to. That could be a big help. But I think when you get there, then using those traditional approaches of really listening and being authentic and caring are so important.
So to follow up to that comment then, so if we, and I think it was excellent comment. So how do we try to provide the capacity or knowledge to encourage, custom or cultural disputes, but also give them extra tools in the toolbox to support that? So I guess that's really the challenge, is how does one get the extra tools to help them to use cultural or customized methods within the communities? So what extra, how do we arm them, with extra, basically, tools to get to discuss it. So that's why I always. So how does one do that?
I think, in a nutshell, what I would say is maybe the community would they may want to, if there's nobody within the community who has yet the experience to develop that, and bring someone in, but the person that you want to bring in, I think, is not someone who's going to tell you what to do. It's going to be someone who can help, get people together and be the spark conversations, and help people develop what is going to be best for them, and then giving maybe some training on those tools. But it would be really a partnership, and it would be really, I think, more led by the community with maybe some assistance from an expert person, but it wouldn't be someone's going to come in and say, hey, this is the way you got to do it, because that'll never work.
Okay. Any more comments here before we're fast approaching 2:00? Any last words? Okay, don't see any. All right, so I guess moving forward here is how to let communities know there's these mechanisms in place. And I guess that's something we need to, I'll probably follow up with you, Richard. And I noticed a few people talked about case studies, and maybe focus on a few case studies and how one would try to resolve that. So, we've had, thanks for that. We got the high level, and now the question is, how do we actually go through some examples? So I believe that might be our next, better follow-up, and understand how do we integrate alternative dispute mechanisms within their existing policies. So we've done that through our manual that Richard helped on housing policies. We have that mechanism built in. So I recommend people get access to that. But I think in their procurement discussions, we may have to have one on how to specifically settle disputes with contractors, maybe a case study. So anyway, thanks, Richard, and everyone. And our next webinar is Claude. Do we have, it's actually in the new year, I believe.
That is correct, John. We'll be
Yeah.
following up probably after the Christmas holidays, that winter break, and be back in touch with what's coming up.
Right, and if people give us some feedback on the questionnaires, on how to follow up on the term dispute resolutions, what we want to focus on, that will help for our planning for the new year. All right, thank you, everyone.
Thank you.
Thank you. Be safe, everybody.
Have a good holiday, I guess. Happy holiday.